Good evening to the participants of the SLW646. Karibusana, welcome to my class of the 19th December 2022. Yes, we are discussing about the cyber space disputes, peaceful settlement of it. So in the last class, we are at this place. Here I am showing you why it is making like this. No. Just a minute. I already opened the file, but I'm checking the file where it is. Just to minimize it. Yes, minimizing the file where I kept. Is it here? Yeah, it is here. The individual electronic filing, no, not this one. Let me go back to it. Let me stop sharing. Then you are sharing your screen. Stop. Okay, let me check it where I kept the file. Yes, it is here. No, not this one. Okay, now I'm going back again, searching for the file where I kept it. Yes, it is here. I don't know why I kept it here, but it is disappeared. Anyway, that let me check it whether it is here or not. Okay, Peaceful Minds, WPS office, it is went over there. Okay, no matter. Now let me on it my yes. Where is the now I found it. Share content and okay, it is gone in this way. Just a minute. Yeah, it is here. Yeah, now find it. I found the file here. The continuation would be here. Yes, 13th, that is the 2 asterisks. I kept it over there. And if you see that with regard to the international dispute, which may endanger international peace, I repeat, with regard to the international dispute, which may endanger the international peace, and the Article 33 of the UN Charter states that parties to the such disputes are to solve their disputes by negotiation, inquiry, or mediation. Of course, in other words, we can also say diplomatic way resolving the legal disputes. So, should these prove unsuccessful, they are to restore to more complex form of resolution. Of course, the easiest form of is diplomatic way. If it is not resolved over there, then you can go to the next mechanism, a bit complex form of it. Therefore, even such a grave circumstances, if such a situation comes, then international peace might be at the stake. The obligation to engage in a negotiation or any other means peaceful settlement of dispute does not hold a binding nature as per international. So at the peak level it will be there, where it will not be binding in nature, and the grave situation comes over there, then we can approach to the Security Council or the UN, based on the UN Charter. That is only the method we do have it. One should be derived, however, from the overreaching the principle of the UN Charter, which obliges the state to act with the aim of maintaining the peace. If it is not resolved by any other means, either by diplomatic means or the grave situation by making the stringent mechanism also, if the other party is not binding over there, then the last resort is Security Council or General Assembly, we can approach it, any one of them. So when applying this method to cyber disputes, it would be easy to imagine states in a cyber dispute to engage in negotiation. But generally that we cannot approach to the Supreme Court or the Court of Appeal when there are many other solutions are available in the lower courts. So when you exhaust the lower court remedies, then we can approach to the Court of Appeal. Is it clear? Participant? Can you directly file a case in the Court of Appeal?
No, Prof.
Where do you file it?
District Court or High Court?
You have to start from the lower court, which is having the jurisdiction to entertain such a case. If it doesn't have the jurisdiction, then we can approach. Like election cases, can the district court is resident magistrate court is having the jurisdiction to entertain such a case, election cases. Yes. If you know it, you tell me. If not, pass on, say. When the matter is a constitutional bench matter and the original jurisdiction, directly we can approach to the High Court, not the district courts. Generally, Election Commission, either a special court is formed, a special bench is formed, or we can approach to the High Court. But in other cases, you exhaust the local remedies first, then you can go to the High Court or the Court of Appeal. Is it clear? Say yes.
Yes, Prof.
Good. So this would be particularly important when discussing the Article 2, Section 3 and Article 33, Section 1 of the UN Charter, which refers to the disputes, the continuation of which would likely endanger the maintenance of the international peace and security. The complexity of evidence and attribution with regard to the cyber disputes is therefore unnatural prerequisite for the parties involved to seek the amicable solution to such a potential conflict. Yes, first and foremost, they can handle by the diplomatic method. That means negotiation, arbitration, and inquiry, all these things should be there. If it is not resolved over there, we can approach the tribunal. Under a particular convention or treaty, if it is not solved over there, then the last resort is the Security Council. Before we are referring to the Security Council, better we will go to the General Assembly to see that the problem will be resolved. If it is not resolved over there, Security Council having such a power that even they can send the peacekeeping force and see that the state should be lowered down, that they cannot be take an action against the weak state. So that was the method, or the diplomatic sanctions will be imposed on the state. So, and they will see that maintenance of the international peace and security, it should be continued. By that way, they can resolve the legal disputes. The complexity of evidence and attribution with regard to the cyber disputes is therefore unnatural prerequisite for parties involved to seek the amicable solution to such a potential conflict. For negotiations to be conducted in good faith, it is also necessary for the state to disclose the forensic evidence that they hold. So, a forensic evidence, and that deals about the finger experts, ballistic experts, and fingerprints, and other any like instruments, blood stains, hairs. Regarding that thing, they will supposed to inform to the state which is going to decide and act as the umpire. So, while trust is always an issue with regard to the cyber security, the well-established practice of diplomatic negotiation in good faith could support a successful application of this method. So a diplomatic method is nothing but just I told you that it is the negotiation, arbitration, inquiry, and so on and so forth. In the international discourse, it has been thoroughly discussed that creating a global center for cyber attribution and forensic evidence might support such a process between the state or among the states. So cyber disputes, it is a very complicated disputes. Still the law is not that much clear, and a few of the countries would be on the treaty, and they try to solve the disputes. As the IPC, there's a Tanzania Penal Code is there. It will also serve the purposes certain extent. If it is not serve the purposes of then a special statutes will be made to see the demand of the changing of the society. Like we discussed SASPA. It is a special act would be made for the sexual offenses where the Tanzania Penal Code is silent. So while the dogmatically plausible creation of such a center seems distant at this stage of international cooperation on the matter at hand, given rising the international tensions, state prioritize national security and are reluctant to share the information on vulnerabilities disclosure. But a certain information will not be disclosed because it is a security problem with the state. So, those are the methods they can use it and try to resolve the dispute in the cyberspace. Of course, the another method is good office and mediation. Negotiations are a method of directly solving the interstate disputes, whereas the involvement of the third state or an institution is also provided for an international law. When third parties need or wish to support dispute resolution, they can reach for the good offices or mediation. They can use their office and call the parties from the different states to negotiate in his good office and try to resolve the issue. Or the mediation. Similar to the negotiation, neither of these is binding and both are to be performed in good faith. Either you say negotiation or you can say mediation. Sometimes they would not be binding enough until they subject themselves to a tribunal or a court. Good offices are a measure that provides for the third party to facilitate an environment where disputing states may stay in their position on a neutral ground and favorable circumstances with the overarching theme to achieve the consensus. They try to take the consensus of both the parties, both the people from the different states or both the states people and reconcile it. So, with the we are divided it as when good offices are being performed, a third party is not to get directly involved in the discussion between the disputing states. Their mandate is limited to ensuring a supportive environment for the exchange of the views among the disputing states. So, further, we want to say that alternatively, mediation implies that the third party is actually involved in the discussion and mandated to offer solution. And however, as Eamon Shaw rightfully notes, of course he is one of the author, the dividing line between these two measures may at times prove challenging to identify depending upon the factual circumstances. The Hague Convention of the 1899 and 907 provided for the specific guidance on how these two processes should unfold between the disputing states. So in the beginning, there is the Hague Convention is there, that is 1899. Later on, to strengthen it, 1907 has come out to resolve the dispute among the states, international disputes, by following the peaceful means. Provisions of these treaties indicate the parties are capable of offering good offices or mediation even when the state had already engaged in military hostilities. It is given the opportunity of the states. They can use the good offices, they can use the diplomatic way of resolving the issues, even though the military hostilities are there. With the caveat, by giving the notice that the extending such a diplomatic measure was not to be recognized as an unfriendly act. So when the parties agreed together, it's well and good. If they did not come to the one platform, that means could not reconcile it, but still they are unfriendly. And implicitly, even in the time of war, here the cursor. States are under an obligation to engage in diplomatic resolution for disputes, including the negotiations, mediations, and good offices. So these are the generally the diplomatic methods of reconciling the states. So mediation might prove the most effective measure of settling the international dispute when it comes to those related to the ICTs, the information technologies. As noted above, the cyber disputes are usually closely linked to the attribution forensic evidence or due to the diligence and state failure to provide it. There are secrets of the state are there, and that cannot be revealed. And that is why the information will not be shared mostly by the state. While the creation of an international cyber attribution center is unlikely, technical expertise offered to the private sector companies or international organizations such as the ITU might prove highly valuable. So, dedicated cyber crimes and cyber security sections within the Interpol or Europol also seems a good venue for the states to discuss issues of the cyber evidence and cyber attributions in an amicable manner. So we can take the help of this Interpol, Europol, like FBI or CBI, CBS, CID, and these are the people those who are given the information where there is a, and of course they give the information which is very much needed to resolve the issue. Otherwise, if the information is against the state security, and they will not reveal it. So, amicable solution, they want to make it out. Sir, you may ask, sir, this what is this ITU? So, here in the ITU, I believe it is this full form. ITU means our full form. Read. What is there on the screen?
International Telecommunication Union.
It is ITU means International Telecommunication Union, that is the International Telecommunications Standardization Sector, shows sources, International Union, and that is a body which will give the guidelines. So now coming back to our study is concerned, yes, let me minimize it. Where it is gone? This is the LinkedIn. This minimize it. Yes, we got it. So ITU might prove highly valuable, and here dedicated cybercrime and cyber security sections within the Interpol or Europol or CBCID or CID or FBI. What is the agency in Tanzania? Detective agency.
TCRA.
What is that?
Tanzania Communication Regulatory Authority.
They do the secret information. Do they do the secret information?
It regulates all the communications.
I am not speaking about the communication. The secret of the state. The crime. Detective agencies. Government detective agencies. Like FBI is the Federal Bureau of Investigation. Interpol is there.
Tanzania, it's police. Police.
Only police? No, there is an agency is there. There is an agency which will deal such a matters.
Yes, no, Professor.
Yeah, because in India, There is a CBCID is there. CBI is there, Central Bureau of Investigation. And in there is Interpol is there, the Europol is there, and KGB is there for Russia. So these are the agencies. So every country they do have the detective agencies to find out the truth, to find out anyone is leaking the state of the security to the other country or not. So similarly, the Octopus Conference, operating with the Council of the Europe in the framework of the Budapest Conventions, would seem like a perfect venue for states to attempt to settle their cyber disputes. So these two conventions also make an efforts like Octopus Conference and the Council of the Europe, then the Budapest conventions would seems like a perfect venue for state to attempt to settle their cyber disputes amicably with the due regard with the international laws and human rights standards. So, by giving the respect to the international laws and human rights standards and those conventions like the Octopus Conference and the Council of the Europe and the Budapest Convention, they try to resolve the cyber disputes. It is regrettable that for no international organization has taken it upon itself to assist states with the differing opinion on individual cyber disputes to find a actionable consensus. Of course, there is no such a platform still it is made, but the people, those who are very much expert in the IT, like India, and they will come forward, take the genius mind of the people and try to make such a platform to find out and make the solution, not making the cyber attacks on their computers or by sending the malware or virus to the computers. So that's they come forward. Of course, other countries also make a good stand, but India comes first in the digital world. This would prove an opportunity for the independent international NGOs or private parties and technical communities. One could look, for example, to the Cyber Peace Institutes as an independent or international private body. So such an organization should be made like the Cyber Peace Institutes and organizations which will tackle the matters of the cyber disputes. So technical and political expertise should also be there. It also be interesting to explore the opportunity for the technical organizations such as the Internet Corporation for the assigned names and numbers. So assigned names and numbers are also important factor like the PIN code. Internet Society or the Internet Engineer Task Force to assist with their skill and expertise in identifying the relevant standard process and modes of behavior for the cyber security and cyber resilience. So now artificial intelligence has grown in such a way it can handle a lot of work. Of course, China also coming very fast by using the software, and they have prepared a lady, a robot having a beautiful face, and she can do all the work, but only the thing she doesn't have is the soul. Are you following me? Are you following me?
Yes, yes, Prof.
Because of the
Yes,
artificial
Prof.
intelligence, there is an initial discussions on the technical diplomacy and the way that technical and standard setter organizations are to play in issuing the international cyber security. Still, the cyber security is a big threat. At any time, your account will be hacked. Please don't maintain the internet banking. If you maintain also, try to change the password every week. Are you following me?
Yes,
Yes,
Prof.
Prof.
And don't give your smartphone to anybody. If they call you, say urgent call, sir, I would like to make to the call to my friend because I don't have charge. Please don't give. Better you ask him, okay, give me your friend number, I will call. because by that way also they can tap it. Your whatever the SMSs would be there in the OTP, they will try to make it out, and within no time they will draw the amount from your bank. So one should be very much careful because there are cyber threats, cyber crimes are there, and which will be rampant nowadays in the different style. So, granted the depth of the skill and expertise of their members, the role of such organization is international mediation of the cyber disputes would be invaluable. Yes, there would be a certain body would be there where the cases of the cyber attacks are more. Among the states, they will keep such an organization. Even a tribunal also will such a in Europe one tribunal, in America another tribunal, in Africa another tribunal, to see that the cyber disputes will be resolved among the states. So, complementarily, should a dispute be referring individual human rights or surveillance technology or a bulk data collection or international organizations such as Article Minds, Teens, or Privacy International could assist states with their policy analysis and technical expertise to better identify the scope and meaning of individual rights impacted by the use of the ICTs. So this is the mediation method when you should have to apply it. And the later we can see the inquiry. Of course, we read earlier also inquiry. But in all the places, the same diplomatic method would be followed. What is the diplomatic method? Participants, a diplomatic method also can be said as a common or positive method. Just now I told you now, mediation, arbitration, inquiry, good office, these are all come under the diplomatic methods. Is it clear?
It is clear, Prof.
So 3.2.3 inquiry. Dispute between the states may regard facts or the interpretation of the laws when the factual circumstances of the case are subject to the dispute. So now an inquiry might be useful to find a peaceful resolution. But in inquiry, the team will go into your state and get the information from the targeted groups. But you have to allow them to go and make the inquiry. That is also an important factor. A commission for the inquiry is to be instituted to support the states in identifying the factual circumstances around their disputes, like a commissioner. Sometimes a commissioner would be appointed to go and see where the dispute is there, where is the land, where is the encroachment, and where is the construction, where is the obstruction, because the court will not go there. But this commissioner will go and make the report and submit to the court. So in that way, inquiry committee also goes to the place where the dispute is there and take the opinion of the people and come with the concurrent report and submit to the government, the party or the tribunal or the court or the body which is making such an effort to resolve the international dispute. So such a commission is to be constituted of a reputable observers. And when a commission would be appointed over there, there should be a reputable observers are there and who are endowed with the task of to identify and objectively describing circumstances of a given disputable case. For instance, if the cyber dispute is there, that means he should be well versed in the forensic lab, ICT, and software as well as the hardware also, and preferably software. So now 1899 Hague Conference provided states with initial guidelines on work that a commission of inquiry should provide. So the Hague Conference is given such a direction and guidelines how a commission of inquiry should conduct the inquiry in particular state. Its report was to be non-binding alternative to arbitration. Of course, it is a non-binding one. and is alternative to the arbitration. If they will not be resolved by the arbitration, let it by the commission of inquiry. So, a commission of the inquiry has proven particularly useful in specific circumstances throughout the year. United Nations has seen an increase in this form of peaceful settlement of the dispute, which have been used in the context of the fact finding. It is a very good method of it because they want to make it very clear what is what and what is what. Means what is the truth and what is the false, and what is the milk and where is the water. They will make it very clearly. So they have been explicitly mentioned in the Article 90 of the UN Charter Protocol, 1 of the 1949 Geneva Red Cross Convention. So they made it very much clear in the Article 19 of the Protocol 1 to the 1949 Geneva Convention, Red Cross Conventions, and which includes provision that allow for the establishment of an international fact-finding commission. It is an international fact-finding commission will be appointed with the observers having a technical expert in the field. As a way of example, one could point out to the 1992 Security Council Resolution 780, which established a commission of experts to investigate the violation of international humanitarian law in the former Yugoslavia. In the former Yugoslavia, there is a massacre was there, the human rights violations are there, and hence the commission was appointed over there for the Yugoslavia and Vietnam War also. Now, since the early 20th century, however, the Commission of Inquiry is no longer viewed as a process independent from other peaceful settlement of the dispute. But nowadays, the Commission Inquiry is becoming a diluted because the state will not allow the Commission members to inquire in detail to get the information from the public and those who are the state subjects. So this is despite the fact that the Permanent Court of Arbitration operational rules for a fact-finding commission of inquiry have been effective of 1997, and this relatively recent example of the statutory fact-finding commission is pursued more as an exception rather than the rule. Oh, now it is not a rule, it is only the exception. We can make it out for the fact-finding commissions are concerned. So these are all about the fact-finding, then the ITU, then the other organization bodies, and they all will work for the cyber security problems and resolve the cyber disputes. So conciliation, because I told you mediation, arbitration, inquiry, and conciliation, these are all the diplomatic method of resolving the disputes. And we earlier also we referred this conciliation in different places. The same rule would be applicable here in the cyber disputes also. So if you just look at the conciliation is that another method of the peaceful settlement of the dispute between the states that involves the active participation of the third party. Such a third party is involved in the process of the peaceful settlement of an interstate dispute to actively offer the solution to the considered in a good faith by the conflicting state. So conciliation, again they need a third party to resolve the issue, and they try to make understanding between the two states. It can therefore be viewed to include the element of both the mediation. It follows the mediation methods, it follows the inquiry methods. Historically, conciliation has originated from fact-finding commission. If you see the genesis of this conciliation, it is nothing but fact-finding commission and a permanent inquiry of commission. So this is the genesis of it, the conciliation is there. And other points also here given and the conciliation as a mean of the peaceful settlement of the dispute has been described in such a much detail in the 1928 General Act on the Pacific settlement of the international disputes. So which was later revised in 1949, and this guidance describes the element of both the commission of inquiry and the third party mediation. There are commission of inquiry and permanent commission, but now the commission of inquiry and third party mediation. So a third party mediation is nothing but a conciliation. So according to this guidance and earlier international practices, conciliation is usually offered with a group of 5 persons, with one appointed by each of the disputing states and three individuals nominated consensually by both the parties. So they are the members. Here it is given what is the constitution of this conciliation. So 1928 General Act prescribed the conciliation committee are to operate no longer than the 6 months, and they are not to be open to the public. Confidential matter they have to make it out. Otherwise, there is a tampering would be there, and they try to threaten there and apprehend them. The conciliation is that designed to address both the legal and factual questions and support the states in addressing their concern in these two categories. So the composition of such a conciliation is to represent both. One is the legal and the case and the specific expertise it is. So in the diplomatic way, by the conciliation also we can resolve even a cyber dispute, as we can resolve the other disputes. And then we go further, tensions between the states have been steadily rising in the globalized economy. So as the evolution of the modern technology is there, and modern weapons are coming into the picture, then the possibility that even the crime rate also will be increased. So these were reflected in the 1995 UN Model Rules for the conciliation of the disputes between the states. It is also observed in the 1995 and United Nations Model Rules for the conciliation of the disputes between the states, which may be viewed as a proof of the increased interest from among the states to re-engage in the conciliation process or procedures. A reference to this specific method of the diplomatic settlement of the dispute also been made in the multilateral treaties, including the 1957 European Convention on the Peaceful Settlement of the Disputes. So this convention also encourages to see that how a dispute will be resolved, especially in the cyberspace is concerned, by following the international norms and instruments and conventions and protocols. So in 1964 protocol on the Commission of the Mediation, Conciliation and Arbitration to the Charter of the Organization of the African Union, now the African Union. I told you that the African Union having their own way, European Union having their own way, and the American having their own way to resolve the dispute in the human rights. In the same manner, when a matter comes to the international disputes are concerned, especially the cyber world, yes, they do have the 3 or 4 regional branches to entertain such a case and resolve the disputes. So this again the conciliation, some more example. Then we will see in the tomorrow class regional organizations, and we do have the regional organizations in our syllabus. I don't know whether you have seen it or not. I will show you the syllabus. Here, peaceful. Yeah, it is here. Yeah, this is the peaceful settlement and our syllabus. If you want to see it, here it is given. Is it visible? Sir, it is not opened. The file is not opened, sir. Why it is making pole pole? I say open. I made double click also. I don't know where it is open. Because there is a X is there is another is there. I want to delete something from here. Asante sana, sikiliza darasa. Mungu akubariki na kukulinda.